My name is Patrick Hatch. I'm an lawyer. Today, I would like to speak to you about deferred action. There's a new process under the umbrella of deferred action called Deferred Action for Childhood Arrivals. This process was announced on August 15, 2012. Now, I'm a member of the American Immigration Lawyers Association, and I have offices in Durham, North Carolina, and Greenville, North Carolina. The details I'm going to give you today are not intended to replace legal advice from an attorney in an individualized setting. This new process we abbreviate as DACA, Deferred Action for Childhood Arrivals. Let me first tell you what this process is not. It is not a new law. The President cannot create new law. Also, this is not the DREAM Act. The DREAM Act would give a pathway to citizenship and give green cards and the right to travel. This process will not lead to permanent residency, will not lead to U.S. citizenship, and does not defer legal status. What will DACA do? DACA will allow someone to get an employment authorization document for 2 years at a time. With the employment authorization document, a person can apply for a Social Security number. With a Social Security number, in most states, the person will be able to get a driver license. Each of those documents will be valid for 2 years, and each depends on the employment authorization document granted under DACA. In North Carolina, we believe that people will be able to get driver license as the law exists today. At the end of 2 years, the Obama administration is saying that the process will have an extension period of 2 years at a time. Now, we have no idea what will happen at the end of the 2 years. We have no idea what will happen in the future, and we have no idea what future administrations will do with this process or with the information that people submit with their applications. Each application will be considered individually on a case-by-case basis, and that same applies to extensions. It is not guaranteed that someone who is granted the first wave of deferred action will be extended. Again, it will be given on a case-by-case basis. So what are the criteria and requirements to prove eligibility? First, a person must have come to the United States before their 16th birthday. The evidence for this requirement could be a school transcript, medical records, or church records related to a specific church event. Next, a person must have continuously resided in the United States from June 15, 2007 through the present time. Again, school records, church records, medical records could be used to prove this requirement. Further, bank statements showing purchases in the United States could be used to prove this requirement. There are many ways to prove this requirement. Utility bills, contracts, leases, children's birth certificates could also be used to prove this requirement. A short trip during that time does not necessarily disqualify someone from DACA. A short trip that is brief, innocent, and casual should not disqualify the person. The next requirement is that someone be under age 31 as of June 15, 2012. And this is very clear and can be proved by a passport or birth certificate. Another age requirement is that the person have turned the age of 15 before applying. You did not have to be 15 or older on June 15, 2012, but you do have to turn 15 before you can submit your application. As of June 15, 2012, another requirement is that you be either out of status or have entered illegally before that date. The education requirement is that a person currently be in school, have graduated from high school, received a certificate of completion, received a GED, be currently enrolled in a GED program, preferably through a community college, or be honorably discharged from the U.S. military. That requirement can be met at any time before application. Someone who dropped out of school can re-enroll and apply once they've re-enrolled in school. The criminal requirements are that a person not be convicted of a felony, a significant misdemeanor, or 3 or more minor misdemeanors. If you have any criminal history, then you should speak to a lawyer about your case. A further criminal aspect requirement is that the person not pose a threat to society or to the community. An example of this could be gang activity or suspicion of gang activity, as well as someone who has many arrests without having any convictions. The government could consider this person a threat to society. The next requirement is that the person be present on June 15, 2012, the date of the announcement, and be present in the United States on the date they submit their application. The requirements to submit the application: you must have a photo ID. You must have a valid passport, a valid school ID, a valid consular ID, or a valid driver license. The application requires 2 photos for the employment authorization document, as well as several forms. In our office, we start with a DACA eligibility verification form, and this is where we sit down with our clients to make sure that they're eligible for DACA, and we have them sign the form listing that they've given us this information about their immigration history. The next form, if a lawyer presents the case, is called a G-28, and that allows the Immigration Service to contact the lawyer about the case. The main form with this application is the I-821D, and that is the form for consideration for DACA. The I-765 is the application for employment authorization and is required with this type of case. The I-765WS, or I-765 worksheet, is the statement of a person's assets, income, and expenses. And the government will use this to determine the economic necessity of granting a work permit or employment authorization document. In our office, a contract is required with every case. And this is where the lawyer states exactly what the client is getting and the fee that they're paying for it. This is a requirement in our office. We sit down and we want to explain how the process will work and exactly what the details are of the relationship. The fee to the government is $465, and that goes to the U.S. Department of Homeland Security. A lawyer will most likely charge an additional fee, and those fees can vary widely based on the circumstances of each individual case. After you apply, you will receive receipt notices within 2 to 3 weeks, as well as biometrics appointment notices. The biometrics appointment notice will come at the same time, about 2 to 3 weeks after applying, and that it lists a date, time, and location for the Immigration Service to take the person's fingerprints and photograph. The fingerprints will be used for the background check. The photograph will be used for identification purposes, as well as creating the employment authorization document. The biometrics appointment will come 1 to 2 months from submitting the application, as currently we've seen in our office. After that, an appointment could be scheduled for an interview. Cases could be randomly selected for an interview so that the Immigration Service can practice quality control. They may also be scheduled in cases where there is suspicion of fraud or someone submitting fake documents. The interviews will take several months to be scheduled from the time of submission. The receipt notice will allow you to track your case online. As of now, the Immigration Service allows you to enter your receipt number, and they will say if your case is pending or has been approved, or if a fingerprint appointment has been scheduled. In conclusion, I want to say that DACA is not for everyone. There are many people who will not qualify and should not apply. Many people will come close to qualifying, but with DACA, close will not be good enough. It will be a waste of time and money to submit an application if you do not meet the requirements. There is no refund for a denial, and there is no appeal process. If a case is denied, it may be possible to reapply, but the processing times could be several months long. There is no guarantee that any one case will be approved. It is wise to at least consult with a lawyer. Whether you hire a lawyer or not, a consultation can be very valuable and informative. A person interested in DACA might qualify for something that is better than DACA, mainly a green card or some type of visa. This video, again, is not meant to replace individualized legal advice with an immigration lawyer. Detailed advice can only be given based on a person's specific circumstances. Our office assists clients all over the country. Many cases we handle by phone, email, and Skype. We have offices in Durham, North Carolina, and Greenville, North Carolina. Please call us if you would like our help. Our phone number is 919-688-1788. You can find more information on our website at www.hatchlawoffice.com. We list the DACA requirements on our website under the tab called Resources. We also link to several government websites under the tab called Helpful Links. We have 3 full-time lawyers. 2 are bilingual in Spanish and English, and we have 3 support staff who are fluent in Spanish. Immigration law is complex and can be ever-changing. Our office is dedicated only to immigration law. Our lawyers are members of the American Immigration Lawyers Association, and I'm proud to serve on the National Pro Bono Committee of the American Immigration Lawyers Association. We are committed to helping people navigate through many U.S. immigration law processes and procedures. We handle all types of immigration law matters. We hope you find this information helpful and educational. If you would like us to speak at your community organization or at your church, please reach out to us at 919-688-1788 or email us at info@hatchlawoffice.com. We're also available for group processing of DACA applications. Thank you for watching.